Trial cases are not over until the person is sentenced. You can reopen a case at any point up until the end of sentencing. So in this case, the trial judge did not honor the principle. The trial judge placed significance on the evidence that it did not properly bear. In the eyes of the trial judge, it became an equivalent of an admission by the appellant of an assault. The conclusion would have inevitably led the trial judge to reject the rest of the appellant's evidence as she did. It was pivotal, it was central, it was significant. It is a basic principle of law. You have to invite submissions on that. There's nothing wrong with thinking about it and going, oh gosh, now that I listen to this over and over, I think this is what I'm hearing. I got to address this with Crown and defense. No problem.
The fundamental principle that you mentioned, it really stood out to me. That's one of the reasons that the Crown must call all of their evidence before the defense calls their evidence, is your right to know the case to be met.
Right.
And so it's also one of the reasons we have disclosure requirements, where the Crown can't hold on to evidence and then surprise you with it later. Right. When you're the accused and you're kind of the underdog going against the power of the state, you have a right to know what their case is, and it's the obligation on the Crown to prove their case. So when you end up with a judge who then alters evidence...
The judge is not altering the evidence. The judge is coming to a different conclusion about what the testimony means. And that's fine, no problem. But you must alert the Crown and defense to now coming to a different conclusion and invite submissions upon that, so that there is a fair approach taken, so the accused, again, is aware of this issue, knowing the case that they have to meet.